There's 5 watching already.
Christopher Robin, what exactly is doing nothing?
Well, I'm told it means going along, listening to all the things you can't hear, and not bothering.
Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to a very special Our Curious Amalgam. It's the Our Curious Amalgam California Privacy Live Stream, a live stream about California privacy. My name is John Roberti, and I am here with 3 experts on privacy law. To my immediate left is Elisa Hutnick, who an expert privacy law who leads the team at Kelly Dry. To her left is Carmen Heimbauer, another privacy expert from Kelly Dry, and to my right is Lauren Myers, and today also a privacy expert from Kelly Dry.
Wow,
and today, here's what we hope to do. We're going to try to talk a little bit about what's coming up with the California privacy law. It's right around the corner. The implementation date. It's within months.
Countdown, yeah.
Yeah, I mean
January 1.
January 1. So. And, you know, we have Thanksgiving and then we have Christmas and then all of a sudden we have California privacy. So we wanted to start off by talking about what's coming, talk about what people really need to know, and answer any questions that we have about California privacy. So I'm going to turn it over to Elisa, again, who is really the expert on this.
Well, feel free to interrupt me. California CCPA, I would say, kind of going back, comparing this to any other privacy development is really a whole new animal. And partly it's because of how comprehensively it really changes companies' business practices. I mean, I don't know about you guys, but it used to be you'd have some state privacy questions in the midst of the federal ones. And these days it is CCPA from the very beginning, as soon as you get in the office, and straight through the evening. I mean, it is nonstop.
I told you I wasn't going to talk very much, but I do want to ask you one question. So California is one of 50 states.
Yes.
Say you have a client sitting in Michigan. Why should that client care about California privacy?
That question is particularly why there's suddenly an uptick as companies think like, this is California. I don't need to worry about this. And what's different is that every company, for the most part, has some type of digital presence, right? You're advertising online. That's usually how you're going to get viewers. Well, anytime you're targeting California viewers, that online data, you're subject to it. So it's not just where the company is, but it's who are your customers, who are your audience that you're trying to reach to, and what kind of data are you collecting from them. Hugely, impactful. And so, yes, it's just a state, but now that in the absence of a federal law, that is the comprehensive, by default, national privacy law for now. Yeah, and I think one of the questions that companies in trying to figure that out, when you have a law that changes your operational processes so much, it's hard to parse out, I'm just going to do this for California and not for the rest of the country. And some companies want to lead with that, saying we're putting consumers first and we're leading with privacy. We're going to take this law and apply it to all of our practices nationwide. And then others, this is new, right? Even if they want to do that, they want to roll out the program and make sure it's working before they overpromise. They are focusing on California only. And then they have to have a process to, when you have your Nevada consumers reach out to you and say, well, what about me? Can I have these records? You're going to tell them no. And you need to have a good story to be able to tell them why not.
And to that point, it's really interesting because the law itself is still very new, and we're still figuring out what are the regulations going to look like. What do we really have to do with some of these definitions that aren't completely clear, or expectations that haven't really been really straightforward yet. So there's so much that's up in the air. A lot of companies are trying to wait, too, to see what it's going to look like before they decide if they're going to roll it out completely.
Right. No, that's an excellent point. And if anything, that's probably why this law is causing so much angst is, unlike GDPR, for example, which you had 2 years of time to implement, you had a lot of guidance, so there was a decent amount of consensus and level setting. California's law, it's been a sprint, right? So we've got the law was passed, a lot of issues with it. Then you had amendments that were introduced. Maybe they'll happen. If they happen, they would really make a big impact in terms of how you execute the law and implement it. The amendments passed and signed in October. So, right? We're
October,
in
like
October.
October, like last month,
yes,
October?
As
Okay.
in that, right? And on top of that, you had the Attorney General publish draft regulations also in October, and not on only a few little things. So you're designing these programs that are top to bottom, understanding what kind of data you have, what gets triggered, what doesn't, look at all of the relationships with your partners, with your vendors, how do you classify them, and be ready by January 1.
And part of the conversation about that is whether or not to implement the draft regulations, because those, as the name suggests, are drafts, but they change quite a few definitions, quite a few ways that you would approach implementation, I think. And so that's an interesting conversation that we're having as well.
What about questions? So we talked about questions. Okay, I get it. So somebody in Michigan may have a question, but what about somebody in the United Kingdom? I mean, are you getting questions as you're implementing this from outside of the U.S.?
We're getting questions at yes. So the short answer is yes. And partly that's because where is your audience? And now we're such a global community, it doesn't stop at borders. And privacy laws also are not stopping at borders these days from a practical perspective, and some of the laws directly applicable.
So just as a consumer of stuff, how will I see the California privacy laws in my life? What will change for me? What will be new?
From a consumer perspective, I think particularly as everything really moved to digital, right? The lack of awareness as to how much information entities, and I say that word really broadly, have about you. I mean, to the point on they know what you're likely to buy, when you're likely to buy it, who you're friends with, what your habits are, where you drive, where do you work, where's your home, when do you typically go on vacation, what profile, what segment do you fall into, what decisions are being made that you never have a say in. And so the point of this was really to bring a lot more transparency to that so you can see. And you can actually have a say in that you are vested in your own data and can make some decisions about whether it can be used for certain purposes or not.
So what are the 2, 3, 4 things that companies that's most difficult for companies that they've got to do between now and January 1st?
So unlike Europe, right, where I think companies were forced a lot earlier to understand what kind of data they had, now, more than any time, I think, really to date, companies have to do the very burdensome and hard, real deep dive into what their data is. And not as hard for the startups, but for companies that have been around quite a long time, it's one of those things you always perhaps wanted to do but didn't have resources. You have to do it. You have to know what is personal information. And I think that's a cultural difference because in the U.S., we had I would say, fairly stringent definitions, right? You know the obvious, right? What's your name, where you are? And then we, over time, and the Federal Trade Commission certainly has been pointing to this direction for a while, has been using your online IDs and what information tracks down to your device or your internet browser that you use. That's a broader sense that is personal information. And so once you widen the tent to include that information, Now you have to think about what are your business practices in relation to that data. So from a business standpoint, if I don't yet have these practices, or I'm so used to the practices I do have practices, but now I need to change them in a very different way than I have. And when I look around me, I don't see I don't see consensus in the industry. So I have to make some decisions internally on which way I want to go. And so I think, starting with knowing what your data is and how you are going to classify it for purposes of, and we'll get into it, but some of the way that the CCPA regulates it. I don't know, what do you guys think? We're all answering CCPA questions every day, so we each get hit with slightly different ones.
Yeah, I think one of the questions we get a lot from clients is like, what are our service providers or the companies that we're working with to provide these internet technologies? What are they doing, and how do they fit into the law? And what do we need to do to make sure that they're classified the way we need them to be for us to apply the law from the position that we're in? And it's an interesting question because, like you said, consumers don't necessarily have complete knowledge about all the ad tech and all of this underlying online system that's working together to provide them with targeted ads. So for companies now, they're really thinking through maybe some questions they weren't thinking about before, like what are these tags? What are they used for? Why do we have them? And what are we doing with that information? And what are our vendors doing with that information?
Right. You could refer to them as, these are my business partners, or maybe they're my service providers or vendors, but you didn't have to get so precise. And now you really have to get so precise into the relationship and make sure that you are classifying them correctly.
Okay, I have a listener question, and that is, based on what we know now about the law and the regulations, how different is this new law from current laws in the U.S. and from GDPR? And the follow-up question to that is, okay, let's say you have a client that has figured out GDPR.
Yes.
What else?
Right. First of all, it's a compound question, but we'll take it. We'll take it. So that, I would say, let me flip it. We often get the question, I've already done all of this homework and effort and put resources in for GDPR. How different is CCPA? Can I just use what I did for GDPR and call it a day? And what our answer typically on that is, you can leverage, you can use a lot of that, but it's not exactly the same. You really do have to have some separate instances. And I would say some of the big differences, GDPR focuses on, do you have the right legal basis to handle the data? And it's often opt-in. A lot of things are disclosure and you have to opt in. Whereas CCPA, it's opt-out, but you really have to classify the data flows, and they use different categorizations. So unlike GDPR, you've got who's the decision maker with the data, called the controller, and they call the processor, which is your service provider that just does things on behalf, and that's very specific. We now have 3 different entities in CCPA. You've got your business, you've got your service provider, and you've got your third party. And the question is, the data flow with a service provider, or is the data flow a sale under CCPA to a third party? And that's not a concept that GDPR really addresses.
Now, you used a term opt-out and then opt-in.
Oh, very lawyerly, yes.
Who is when you say who is opting out, who is opting in? What did you mean by that?
That we could spend a whole hour on that, just because it's so litigated. So opting in means a consumer is making an affirmative choice. They are doing some type of affirmative step, like checking a box or signing a name or pressing a button that clearly and ambiguously signals they want whatever that is. I want to receive your marketing newsletter. I'm checking the box. So that means the disclosure is very specific and clear, and the action by the consumer is also very clear.
So you said an opt-in was which?
That's opt-in. That's opt-in.
And who is opt-in?
Opt-in is GDPR.
Okay.
Europe.
So if I want the protections of GDPR, I have to check a box or I have to do something.
You have to know exactly how you're processing your data, what you're doing with your data, and consent is one way. The opt-in is consent, so that is one way to do it. There are other options, and they just, depending on the situation, you may rely on those versus consent.
Well, I just want to clarify really quick, because the way you frame that question, I just want to make sure anybody who's watching or listening understands, the consumer doesn't need to opt into GDPR protection. That they have GDPR protection.
Yes.
It's that they need to consent to the company using their data.
I see. So the opt-in is the opting into the company using the data.
For this certain reason.
Got
specified.
it.
Yes.
And so in California, it's the opposite.
For the most part, and I'm not talking about children's data, but for the most part, it's you as the company have to be very transparent to what you're doing with the data. And if the consumer does not want you to use their data for marketing reasons, called a sale, they can opt out of that. They can tell you, you must not sell my data. You must not share my data with third parties so those third parties can use it for their own purposes.
Got it. So if the consumer doesn't say, don't use my data, the consumer says nothing, the company can use the data as long as they're otherwise in compliance with the regulation.
Right. So that works. And we're speaking about this as if it's a one-to-one. John, you're telling me you don't want me to use your data. But think about this from an online circumstance, right? So maybe I don't know it's your name. I'm really just focusing on a tracker on your device that tracks your behavior so I can send you interest-based advertising. There are a lot of parties involved in that. So if you say, I opt out, I need to handle that, right? I need to make sure that that is honored. And we have some existing self-regulatory frameworks that address the similar concept, but they're not designed specifically for CCPA.
Okay, I see another listener question, and I think it goes back to something we asked before, which is why would somebody in Michigan be subject to California law? Relatedly, is Congress going to pass a nationwide privacy law?
We shall see. I think if you had asked me that 6 months ago, maybe even 6 months ago at a minimum, I was a lot more optimistic that might happen because you have, unlike, for example, data breach laws that you can harmonize, it's one notice, you can harmonize among the different states. This relates to companies' operations. So to have California say, you must do one thing, and then have Washington State, if they pass a law that says you have to do it a different way, it's hard to parse out your operational practices for those different states. So we thought that probably would give enough of a reason for Congress to pass bipartisan legislation. And there were a lot of drafts that, definitely looked like there was promise to it, but they break down over the concept of called preemption, meaning will that federal law prevent that California law from being effective? And that became very volatile because you have California saying, federal government, do not dilute our privacy laws. We will not agree to this. And that's where it got stuck.
Yeah, that's really the biggest sticking point, I would say, is what is preemption going to look like? And it seems like a lot of people in Congress who are willing to pass a law that doesn't preempt the California law. It's only to the extent that the new law would be even stricter than the California law because obviously there's so many conversations about privacy right now. It's such a hot topic. People in Congress want to make sure that they're doing something that will actually protect consumer privacy and that they can point to and say, we've heard all the problems, we've talked about all the issues, we've done something about it. And that's really, I think, what they're looking to do.
Yeah, and, it's interesting because at the same time, Congress gave a lot of pushback to the FTC for the Facebook settlement that happened and saying that it should have been stricter or they should have done more. And it's interesting because the FTC's response was, we did what we could with the tools that we had. So it's an interesting conversation that's happening from both sides.
Right. You're not doing enough federal government on privacy, and yet we're worried about you doing too much.
Mm-hmm.
So who doesn't want to pass the privacy law?
It depends on what privacy law we're talking about. I think you definitely have a lot of constituents that like what California passed. It did provide various rights, and they don't want that to be taken away. They don't want various carve-outs, and I think there's definitely a decent amount of skepticism as to whether a federal law might do that.
Would you expect, and again, we're really speculating here, but would you expect that a federal law would probably be less restrictive than the current California law?
I think it would be different. So I don't know that I wouldn't probably call it less restrictive, but I know that there's a decent amount of analysis. When you cut down data flows, those are choices, right? You're emphasizing the importance of privacy around certain more seamless data flows, and there's an economic impact to that, and that's a choice. And I think that in an ideal world, there might have been time to look into and see more analysis on what happened with GDPR, because there's some studies that are coming out, and at least factor that in. You may still make the choice to have robust privacy laws, but be on a more informed basis to know it will likely have some of those impacts. And there's a lot of free services online that some constituents would say that's not going to work under this very rigorous compliance framework. And what about small businesses and startups? How are they going to be able to do that? So those are some of the concerns.
And I was just thinking, California has a very large congressional delegation, obviously. It's a very large state. If that delegation is not on board with...
Exactly.
Yeah, that's where we've seen a lot of pushback on the federal level is a lot of California legislators in Congress now are like, we want to make sure that we're protecting this law. This is what our constituents wanted. That's really the push for why the law came into place in the first place. And so we don't want to do anything to detract from that.
Right. And just think of it's hard to put the toothpaste back in the tube, right? So January 1's coming up really fast.
I've tried to do that. It doesn't work.
I believe that you tried to do that.
It's very expensive to buy new toothpaste. Go ahead.
But taking the toothpaste analogy, but once you have these rights, suddenly to have a federal law come and take them away, I don't think that would play very well. So that I think it's really at this point, if there's a federal law passed, how does it build on California's framework? And because more and more companies started to recognize that this law wasn't going to go away, now there's a bit of a panic to make sure that they are putting the right amount of resources in, they understand it, and they're complying with it.
And I think there's an argument or a push now for businesses to be really, really involved in the privacy space and to make sure that they're implementing privacy practices that are actually protecting consumer privacy, because it's such a big conversation, right. And consumers are so much more aware of what's going on with their data and on the internet, that businesses are also now asking for laws themselves because they want to know, they want to have some certainty as to what's required of them and how they can protect consumers.
So Lauren, I want to follow up on something that Elisa said with you. Is okay, suppose California has one way of doing things. Washington State, New Hampshire, Michigan. They all have different ways of doing things. How do you comply with that?
Yeah, I mean, that's a big question. That's what a lot of companies are. That's why a lot of companies want to push for federal legislation at this point, because California's law is already out there. A lot of them want to say, hey, we're not sure if Washington passes something, if Nevada passes something. We don't know how we can harmonize all of these things, especially because, as Elisa was saying, data is so dispersed. It's used in so many different ways. It's hard to track it back to a specific consumer in a specific place. So it would definitely be difficult for companies to comply with 50 different federal laws.
But Lauren, isn't that that's the future pain point? That pain point doesn't exist yet. And so it's what will happen, right? Will other states, will they be so different? And then you have something more specific that might give enough momentum to pass a comprehensive law. But that's not happening anytime very soon,
right.
I would say.
So there's sort of, if you think about it, there's sort of a few different ways that this could play out, right? So imagine a state passes a law that's less restrictive than California. Well, then you still just have to comply with California.
Right.
Imagine a state passes a law that's more restrictive than California. Well, that creates the new standard, so you probably have to comply with that state's law nationally. Where it gets tricky is what if they're different?
Well, that's what you're saying, more restrictive, but often it's the devil's in the details, and it just requires a different pathway and a different way of analyzing. So that will be tricky. We are keeps us pretty busy.
Okay, we have a listener question. Is there a unified definition of PI under the CCPA?
So there is a very broad definition, and it includes the kind of information that we would normally treat as personal information. And then it takes the broad scope of, do you have other information that is linked to a person or a household or a device? And that includes things like IP address, unique IDs, location information. So even something that, let's say, under current federal laws, it is a broader definition. And I think that there is... I think we're all on the same page based on the definition of that, but certainly some companies are going to probably try to interpret a little differently. Well, time will tell how that plays out.
Carmen, another listener question for you.
Sure.
Does CCPA reach the Internet of Things?
Yes. I think so. I think CCPA reaches everything, and the Internet of Things is becoming, increasingly pervasive.
So help me understand the question I just asked, because I read it. What does that mean? Does it reach the Internet of Things?
So I think it means For connected devices, sorry, go,
right? Yeah,
go for it.
no. I was just gonna say it's like it depends on the device, right? So if it's the device that connects to your Alexa, that's information. That's connecting information to a household or a person, as opposed to a government IoT or a commercial Internet of Things type of thing. I think then you'd have to do the analysis. It's not fully out of scope because CCPA is broad, but you'd have to do a slightly different analysis.
Okay. So, Lauren, this one's for you. I know a little bit about GDPR, enough to be dangerous, and one thing I know is that there are super big fines if you don't do it right.
Yep.
What about under the CCPA?
So the CCPA's fines, it's a different system. So the CCPA's fines aren't as great as GDPR, but they can multiply. So there's a set limit per every violation, and the question is, if a company violates it, how could that be multiplied?
Right.
So it can actually get to be pretty big.
We get to monopoly money pretty fast. And that's both the Attorney General has the ability to do that, and I think the big question is, what does private litigation look like under CCPA? Because expressly, it's supposed to be just limited to data breaches, which, by the way, that's not a little thing. I mean, there's tons of data breaches and there's statutory damages, so that's a big thing. But we are a very entrepreneurial society, and so I would expect to see plenty of attempts using other state laws like false advertising, unfair deceptive practices related to the notices that CCPA requires and whether they were accurate or allegedly misleading. So I think we're going to see a lot of financial exposure there that is going to be pretty costly for companies.
Let's turn to law firms, which is interesting to a lot of our members. How does this impact law firms?
Oh, that's a good question. So one of the developments we certainly saw that really kind of carried over from the EU is you saw many law firms having cookie banners. And what happens, and I'm going to take the law firm example because it's relevant here. Does the CCPA require cookie banners? Do we need to update our privacy policies? Well, we're going to have to think about that because while cookie banners are not required by CCPA, we still have a privacy notice if we are collecting consumer data. There's a carve-out for employee data, but it's a limited carve-out. We need a privacy notice for those employees. But I think of how much are we doing interest-based advertising as a law firm, and certainly there's plenty of cookie usage and tracking. And so case-by-case analysis, depending on the kinds of third-party cookies that you may be using, whether you need to do more than what you have right now.
And that goes back to the point that Elisa made earlier of just like really knowing your data and really knowing what you're doing, what kind of information you're collecting, how you're using it, because really it's hard to say. You can't say the CCPA blanket applies to organizations in X field. It really, really depends on what you're doing with the data you have, whether you meet the thresholds of the definitions. But if you don't know what you're doing with your data, then you could be putting yourself at risk.
Right, and there's certain practices that definitely have consumer data, right? Think of like class action where you have a lot of participants and you have their personal data, just the law firm's maintaining it. And so you really need to parse that through and know what each of your practices, what kind of data that they're storing.
Okay, so I'm going to ask a question that is my own question, not a listener question. What is a kind of business that you've gotten a question from about California privacy law that you didn't think would really be thinking about that type of thing?
Oh, I've got some good ones. A psychic? Yes.
I did not see that coming.
Like to keep you surprised. So that was one, and that's a true example. We certainly have some others. Let's see, dog walking services, rideshare services. A lot of mobile apps are doing so many interesting things, and there's a decent amount of data. And so each one of those is a different analysis. Oh, I know we've got some other fun ones.
Yeah, just on the psychic, I assume that it's not covered if the psychic just knows
That's
your
what
data.
I asked.
Okay.
It didn't, not so much.
Yeah. Well, what if you could each think about what do I don't know anything about privacy law. In fact, I'm terrifying when it comes to privacy law. So what are the 3 things or 4 things that I really need to know if I get a call from a client so I know how to direct that call to somebody who actually knows what they're talking about? What do I need to listen for? What are the key things I need to know?
Do they have a digital presence? The answer is probably going to be yes. what kind of data, we've been talking a lot about what kind of data they have, and what analysis, if any, have they done? Have they done GDPR analysis yet that you can start building off of? Because that's going to be relevant, even if they have cyber policies, because sometimes you have done some type of data audit to get coverage.
Yeah, I mean, I think you really want to know about your business practices. You really want to know, you'd want to ask your client, again, what are they doing with the data? What do they know about their online presence? Because if it's a client that has a website but isn't really sure about what they're doing on that website, that's something you'd want to be able to figure out. And you want to know, like, what does their privacy policy currently say? What are those representations? What do they think they're doing with the data? Or at least what are they representing to consumers about that? And that's quick stuff you can look up yourself, which would be helpful to point them in the right direction.
So Carmen, so what I have in mind now is we're going to eat some turkey, we're going to do some shopping, we're going to get through the holidays, and then we're going to be in compliance. What happens after that? Okay, because
Sure.
Elisa started to talk a little bit about litigation. That terrifies me, and the creativity of the plaintiff's bar, which I undoubtedly respect and admire. So what happens next? What goes on? What do companies need to think about after January 1?
So I think, well, first I want to start by saying I think companies need to be thinking about it now, not at January 1, but the enforcement deadline is July 1st, or 6 months after the regulations pass. But because we haven't seen that happen, we're assuming at this point it probably will be July 1st. If they do pass, it's whichever one is sooner, 6 months after that. The thing is that the AG has made it very clear that that's not a grace period. So companies really need to be in compliance starting January 1st. And I think the plaintiff's bar is less of a concern right now. That's more, as Lisa was saying, really in response to a data breach. That's where the private right of action, what we're seeing right now. But I think companies really need to be working right now up to January 1st and need to make sure that they're in compliance.
Yeah, one of the ways that I've said that, just kind of those of us who might be a little type A, right? There's a little panic because it's not going to be perfect by January 1. In fact, it might not be perfect by July 1. So think about what you can get done and keep building on that and making it better and better, because there's no certainty. And you might as well want to have a good faith, reasonable framework that you can defend. And I would emphasize what's publicly facing, what's more obvious, as opposed to what's behind the scenes. And that stuff, it's a little bit less. You have more time to maybe make that better. I'm
going to answer a listener question real quick that's directed to me. No, that's not my laptop, and the laptop case is not made out of wood. So what's next in privacy law? We've now been through the GDPR. We have CCPA. What do you see as the next big thing that's going to come that's going to require clients to, again, really think about their compliance?
I think we're so focused on CCPA that sometimes we're not watching what's coming out of the Federal Trade Commission. And what's always been the case is you look at the FTC's enforcement for essentially guidance on where the goalposts are moving, and watch what the FTC is doing, because I think their goal, they are responding in terms of the feedback to be a bit more aggressive. And so how do you incorporate a lot of that guidance into your overall program?
Yeah. Sorry. The FTC has done a lot with privacy recently. The Google, YouTube, COPPA settlement, Facebook, obviously. So there's a lot that you can pull from those settlements there. But also, I think federal privacy legislation is still a huge hot topic. It's something that people are pushing to happen, and I think that's something that we need to be watching out for to see if it actually comes to fruition, because it could. I mean, it's taking a while, but there are definitely conversations happening and drafts being proposed, so it really could be here sooner than we think.
And I would say the third thing is to watch for enforcement both with GDPR and CCPA, because I think that's going to shape a lot of how companies respond to these laws.
Right. That's a really excellent point, because GDPR is different, but we are seeing enforcement in this technology sector on cookies and analysis. And certainly some of that analysis can be borrowed and applied in the U.S. in terms of a trend line and what is likely to happen. I would imagine some of that will be carried over.
So here's what we're going to do. We're a little bit over time. So what we're going to do is we're going to give our listeners a 3-minute warning. Okay. I'm going to ask you, and we will go as long, if there are additional listener questions, we can go a little bit over, but I'm going to ask you a listener question, and then I'm going to ask you to think about how you might sum up and what's the most important thing for us to take away. So here's the listener question. Carmen, I'll direct this to you. who is CCPA? What is what are the people that CCPA is trying to protect? What is the ethos? Is it trying to protect consumers? Is it trying to protect competition? Is there an element of competition baked in there? What's going on here?
So the answer is consumers. I think that's the answer that I think almost everyone would give. I haven't thought about it from a competition lens. I don't think. Well, I know that's not why it was drafted. Whether or not that ends up playing out, I'm not sure.
I think it's impossible for us to not raise the competition practice given who we are.
It's chicken and an egg, because when you choose and prioritize privacy, that will affect competition. Either directly or inadvertently, there are competition repercussions, absolutely.
Yeah, I'm sorry. No, go for it.
And that's definitely something we're seeing, I'm sure, as you know, from an antitrust perspective, figuring out how do we regulate big tech. What are they doing with data? And that's something that now the CCPA is causing a lot of companies to consider. So there's definitely overlap, and it's something that's in the public eye right now. But I would agree with Carmen. I think just in terms of why was the CCPA pushed through, it was definitely consumers who were actively making that effort.
And we're talking about end consumers of the products, right?
Yes. Yeah.
Okay. Well, look. Let's do this. Can I ask each of you to maybe give us your one big takeaway? And if each of you gives one, it'll be 3. So, what is the most important thing for us to learn, us to know, as we walk away from the California Privacy live stream, a live stream on California privacy?
Sure. So I think biggest takeaway is CCPA is happening. And we're just going to get through it, and it's going to be fine. I think there are a lot of big changes that companies will go through, but it's a step-by-step process.
That's what I told my kids about middle school. You'll get through it, and it's going to be fine. Lauren, what about you?
I think something we've talked about a lot today, know your data. Just figure out what you're doing online, figure out how the laws apply to that, and really know what you're doing and how you want to position yourself when it comes to CCPA. That's really the first step.
Elisa, I'll give you the last word.
Ooh, the last word. Privacy rights are not going to get rolled back. And so I think it is a whole new paradigm that companies need to figure out. How do we adjust? How do we update? We can't cling to some of the way it always was, and it will have effects on various industries. And how do you stay dynamic and use it really as a competitive differentiator?
Well, thanks everybody for joining. This brings us to the end of our California Privacy live stream. Special edition of Our Curious Amalgam. Thanks everybody for joining, and we look forward to seeing you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.